Hello, I'm attorney Kiara Swinton. If you or someone you care about have recently been arrested for DWI in Virginia, you're probably feeling confused, overwhelmed, and wondering what happens next. The handcuffs coming off is not the end of a DWI arrest. In many ways, it's just the beginning of a process that involves the police department, courts, and DMV. It also involves a series of deadlines that can impact your license, your record, and your future. In this video, I'm going to walk you through what happens after a DWI arrest in Virginia, step by step, so that you can understand the process and avoid common mistakes. DWIs usually start with traffic stops. An officer may stop a vehicle because of some traffic violation or some other behavior the officer believes indicates criminal activity. During that traffic stop, the officer is watching the driver closely. They're noting how the driver responds to questions, moves, and anything else that might be an indicator of impairment. Given those observations, the officer may then ask the driver to take what are called field sobriety tests. And the officer may also ask the driver to take a preliminary breath test there on the side of the road to assist in making a decision on whether or not the evidence is enough for the person to be arrested. Given all of those circumstances, the officer then decides if there is enough there for an arrest. If you are arrested, that doesn't necessarily mean that you're guilty, but it does start the legal process. After arrest for DWI, the person would typically be transported to the local police station or hospital for a blood or breath alcohol test. Virginia is what's called an implied consent state, meaning that whenever someone chooses to drive in Virginia, they are agreeing that if they are lawfully arrested for DWI, they will submit to a blood or breath test. It is important to note that if a person refuses this test, it can result in a separate charge and additional license suspension if convicted. Whether you took the test or not, what happens next matters just as much. After the nurse or officer, who is also a breath technician, administers the blood or breath test, the person will next be taken before a magistrate. In front of the magistrate, the officer will review the evidence in the person's case, from how the person drove to field sobriety test to results of the blood or breath test if taken. A magistrate will then determine if there's enough evidence there for the person to be formally charged, and whether the person should be released or held. In many DWI cases, where the underlying facts aren't horrendous and the person doesn't have much of a criminal record, many times the person will be released after the jail deems them to have sobered up. The magistrate may set conditions for the person to be released, such as a bond amount to be paid or a bond amount to be paid if the person does not appear at court. This is often when the stress hits hardest. People might assume that once they're released, the hardest part is over, but in reality, several timelines have already started to begin on what needs to be done. One of the most confusing parts of a DWI arrest is the license suspension. Many people aren't aware that if you're charged with a DWI first offense in Virginia, your license is suspended almost immediately for 7 days. The officer would typically also take your license and file it with the clerk's office. You can then retrieve it from the clerk's office where your DWI case will be heard after the suspension has ended, or the clerk's office will mail it back to you. However, it's important to note that it is possible to challenge this 7-day suspension by raising the issue with the court that either the officer didn't have probable cause to arrest you or there wasn't probable cause for the magistrate to issue the charge. And if a judge finds in your favor, you can have your license returned before the suspension period ends. The person's case will then proceed through the legal system. The first court date is typically what's called an arraignment or an advisement. At this hearing, a judge will typically make the person aware of the charge, the penalties for the charge, and the person's right to have an attorney. In many courts, the next court date will typically be something called an attorney review date. This is a date for the court to check in to see if you have an attorney or if you need more time. If you have an attorney by this date, it's typically waived so that no one needs to appear. Next, we'll be setting your trial date. This date is typically a month or two out to allow time for you or your attorney to request and review the evidence in your case and prepare for trial. This evidence typically includes the officer's body and dash camera footage, police reports, test results, and test procedures. It also allows a window of time for negotiations with the prosecutor if that is appropriate in the person's case. There are several myths or misconceptions that we often hear as defense attorneys. One is that refusing a blood or breath test will avoid all consequences. However, that is not necessarily the case, and when done unlawfully, it could result in additional charges or convictions. Another misconception people have is that explaining themselves after they're pulled over will help their case. That's also not true. Oftentimes, statements like, "I only had 2 beers 2 hours ago," will be used against you and hurt your case. And lastly, many people are unaware of how tightly officers scrutinize their actions after the person is pulled over. Anything from handing your license over too slowly, responding in an unusual way, or not getting out of your vehicle smoothly if asked to perform field sobriety tests can be used against you in a DWI case. After a DWI arrest, what you do next matters. You should be careful to note any court dates or deadlines. You should contact and consider hiring an experienced attorney to help you with your case. You should also avoid speaking about what happened publicly so as to make sure you're not saying anything that could potentially be used against you. You should also actively participate in your defense. It's not safe to assume that the case will just resolve itself. It is also important to note any notices or documents you might get from the court or the DMV while your case is pending. A DWI arrest is serious, but it's not the end of the story. Understanding the process can help with making informed decisions and avoiding potential mistakes. If you or a loved one have been charged with a DWI in Virginia, I encourage you to contact my office at 571-322-6289 to better discuss your rights, any potential defenses, and address any other questions you might have about the DWI process.